Yes, please, you may start.
Good morning again, everyone. This case management conference is in the matter of case number CFI 060-2023, held before His Excellency Justice Nasser and Nasser. The claimant is represented by Reed Smith LLP. Lead counsel is Ms. Antonia Burt. The defendant is represented by Adel Shaw Goddard, Middle East LLP, and the lead counsel is Mr. Patrick Thomason. Thank you, Your Excellency.
Good morning. Welcome to the DFC court. We'll start with the claimant.
Good morning, Your Honor. Good morning, counsel on the opposing side. We are at the CMC today primarily to address two remaining issues regarding the procedural timetable. If Your Honor allows, I will spend just a couple of minutes setting out the scene for these issues and addressing some of the points made in yesterday's note, which was submitted by the defendant's counsel, following which I'll move to address each of the issues one by one.
Okay.
Thank you. The high-level underpinning, the high-level facts underpinning the claimant's claims are as follows. 4 employees moved from the claimant to the defendant and took confidential information, which they then misused at the defendant. That's the high-level basis for the claimant's claim. And as Your Honor will have seen in the case file, on 30th of August 23, Sir Justice Jeremy Cook granted the claimant's request for an ex parte application to order the defendant not to use the claimant's confidential information, to preserve the claimant's confidential information that it does possess, and to deliver up the confidential information. The defendant had not opposed the set aside, not applied to set aside the order. And a feature of the case that is relevant to today's case management conference, which I will come back to in a moment, is the asymmetric knowledge of the parties. The defendant necessarily knows and is the only party that knows the extent of his wrongdoing. The claimant does not know the full extent of the wrongdoing. And that's one of the issues that I will address again with respect to both of the disputed issues relating to the procedural timetable. Very briefly, the disputed issues, one is the date for standard disclosure. I'll address that in a moment. And the second issue is the date for reply expert reports. It really, from our perspective, is unfortunate that we have to be here at all for this CMC, as the parties have been discussing these procedural matters since the 6th of November, when we had provided to the defendant a full suite of CMC documents, including a draft procedural order, the case management information sheets, the case memorandum, and the list of issues. Since then, there has been significant delay in protracted correspondence, and that is relevant because yesterday the defendant submitted a note for Your Honor's preparation for this CMC, in which it now focuses on a somewhat new issue relating to these disagreements regarding the dates. So after months of extensive discussions between the parties, it was only on the 22nd of December that the defendant filed a second request for information, even though it had previously filed a request for information earlier on the 22nd of September. And now yesterday in its court note, it focuses on this RFI as the primary reason as it appears, for some of the extensions and delays that it is now requesting for the timetable. I just want to make it very clear that this second RFI is patently a delay tactic It has not been made without any basis that the defendant has explained in the RFI. And it is clear that on the defendant's own case, if it had any concerns about the claimant's quantum case, it should have made those much earlier. It had the particulars of claims since the 12th of September. And now in the defendant's note yesterday, the defendant alleges that the claimant's quantum case is unparticular. This is wrong. The defendant has not identified any explanation for this allegation. In brief, in the second RFI, the defendant requests information which will be provided as part of standard production, which will be evidenced via witness evidence, and which will be addressed in expert reports. It's not the type of information that is typically included in particulars of claim. To be clear, we have not yet had a chance to respond to the second RFI because, as I say, it was filed only on the 22nd of December. And if I could come back, Your Honor, to the point I made just a moment ago about the asymmetrical information. The defendant is the only party that actually knows the full extent of its wrongdoing. That's what I said a moment ago. And it goes to this RFI, and this point goes to the dates that we need to agree today at the CMC, because the claimant has alleged that a very significant number of its clients have moved their business from the claimant to the defendant after the 4 employees left. That's the essence of the claim. But the claimant does not know whether each of these clients that have left have actually moved to the defendant. The claimant cannot know this information because most of the clients do not inform the claimant of this information. It is only the defendant that has the full information of which clients have in fact moved, because the defendant knows which clients it obtained from those 4 employees, via those 4 employees, and which of those clients were previously with the claimant. That's what I would like to repeat again in terms of the asymmetrical information which underpins the dispute regarding the dates. So in our view, the defendant is attempting to confuse the court with its most recent RFI in order to delay the overall proceedings, but that is it. The difference between the parties in terms of the overall length of the proceedings is that on our initial procedural order, the claimant had proposed a hearing in June, July. We are now already, due to some of the delay that happened over the last 2 months, proposing a hearing at the end of July. The current date proposed by the defendant for the hearing is towards the end of November, or November 24. So that's the difference in terms of the overall delay to the resolution of the dispute. So that's all I wanted to say in terms of generic comments. And with that, I would turn to the 2 disputed issues. And I will start with the first issue, which is standard production. I should briefly say that there are 2 other minor issues that are also disputed, but since those are very minor disagreements, we can possibly consider them once we've discussed the 2 key disagreements, because it may be that the parties are able to agree those minor issues once the 2 significant issues have been resolved. So the significant issue, number 1, standard production. What we have proposed at the moment is a date tomorrow for standard production, and we'll explain the reason for this now. The defendant, on the other hand, is proposing a date in 7 weeks' time. In our view, the defendant should have been working on standard production since it received the submissions, including the statement of reply, which was filed in late October. And we reminded the defendant of this very explicitly on the 29th of November in correspondence in later December. The DFC court case plan provides that the parties agree a CMC within 7 days of the statement of reply. That would have been by 7 November 23. The CMC should then be held within 4 weeks after the reply, which would have been the 28th November. And standard production would then follow in 4 weeks, which would have been the 26th December. So standard production should have happened already, but for the delay that occurred in the meantime. We have, as I say, addressed this issue in correspondence and requested the defendant's explanation as to why there is such a 7-week additional delay that is necessary when standard production should have already been prepared over the last 2-month period. The defendant has not provided any explanation. And in our view, therefore, the defendant already had all the time necessary for this step. And now the 7-week delay is purely gratuitous. Especially because the defendant says in its case management information sheet that all it expects to produce is 1 bundle of 500 pages. So it is unclear why that would require 7 weeks. Very briefly, the reasons that the defendant had previously stated for this 7-week period are the following. It provided 2 reasons until recently. Those were the festive break over the New Year period. And second, the fact that the defendant outsources its IT function to an external third party, which is not experienced in dealing with disclosure in DFC court matters. Those were the grounds that were cited on correspondence in the course of December. Neither of them are, of course, relevant. Even the 1-week festive break, even if taken into account, that does not warrant the delay that is being sought. And of course, using a provider that is does not comply with the court's duties to further the overriding objective is simply not satisfactory. And very briefly, for the first time on the 3rd of January, and now as repeated yesterday in the note to Your Honor, the defendant argues that it needs more time for standard production because of this RFI that I've addressed a moment ago, because it has these requirements regarding the quantum case of the claimant, for which it apparently needs to obtain information before it can provide documents. I can only repeat once again that this is illogical. The RFI is no more than a delaying attempt, and it is simply illogical to say that the defendant cannot provide its standard production beforehand. As I said, the defendant already knows what clients moved from the claimant to the defendant. As I said, only the defendant knows this. The claimant does not know this until document production. And another point as well, as already stated in our case management information sheet, we will be requesting relevant and material documents relating to the clients that moved in our document disclosure stage. And as such, there will be even more opportunities for the defendant to search for documents relating to each of these clients. So the 7 weeks that are now being requested for standard production are inappropriate and disproportionate in our view. The second point is the issue of the expert reports. Would Your Honor prefer if I stop here and give an opportunity to address the first point to Defendant's Counsel, or should I continue and address the second point now as well?
No, you can address the second point now as well.
Okay, thank you for the guidance. Thank you for the guidance. So the second point, briefly, is the period for reply expert reports. The defendant now seeks 3 months to file reply reports. To be clear, this is a departure from the defendant's own initial position. When the defendant initially proposed dates for the expert reports, it agreed with the 3-week period. That, of course, is typical under the DAC court case plan. Defendant's not explained why the period needs to be 4 times longer than the case plan provides. In our view, the 3-month period is unjustifiable. It's one of the reasons the defendants noted was that the claimants will have more time to prepare their expert reports. We do disagree with that. The quantum expert report in particular, which appears to be the main issue relating to which the defendant has made comments, can only be prepared once document production and witness statements have been filed, because the information, and that goes also again to the RFI that was just requested, the information that relates to each of these clients, etc., will be part of document production and will then be addressed in witness evidence, and that will be the basis for the quantum analysis. So the defendant cannot really be at any disadvantage as compared to the claimant's expert in this regard. And I can only repeat that, again, if there is any disadvantage, it is to the claimant side, because the defendant already has the information regarding the numbers of clients that moved, and the defendant could already engage a quantum expert to consider the impact that those clients will have had on the claimant. That's the asymmetry of information once again. And to be clear, there hasn't been any explanation as to why the claimants, why the quantum case is so complex that it would require a 3-month period for reply reports when the matter is sufficiently straightforward, in the sense that what the quantum experts will be doing is looking at the clients that moved and then looking at the loss in terms of the value that has been of business that has moved. That is, in simple terms, the analysis that will be undertaking. As such, it's not a hugely complex situation that would merit going outside of the court plan. And very briefly, I have to mention the FTI emails, because the defendant relied on those again yesterday in the note to the court. What happened here is that to justify its 3-month request for this expert reply report period, the defendant has written to an expert firm, FTI, regarding a question. And what it has done last week, the defendant submitted an email from FTI, which is only a partial email, in which Mr. Beck, an expert from FTI, suggests that a 3-month period for reports is appropriate. There is a serious issue here in the sense that it's on the date of the email, which is 15th December of last year, Mr. Beck informed the defendant that FTI is conflicted and FTI has been engaged by the claimant and that he cannot assist them with the matter. He never provided any specific information regarding to this particular dispute, as clearly he couldn't have due to the conflict. He never permitted FTI, the defendant, to use this email in any way. Nonetheless, this email was submitted last week and now again relied upon yesterday as some form of evidence that 3 months is required for expert reports. This is frankly inappropriate to the extreme. And what we have done is we have submitted an email that predates this email, which is the email in which the defendant actually set out the scope of work to Mr. Beck. And Your Honor will have seen that in the bundle. It is at pages 1 to 6 onwards. And that email shows that the scope of work the defendant provided was very generic, clearly not specific to this particular case, as Mr. Beck has now commented. So his casual view in respect of incomplete information, of course, cannot be taken as any kind of indication. It is only natural that an expert, when confronted with a request to prepare a report within 3 months, would necessarily agree that the additional time is useful. And now, as I say, yesterday again, there's reliance on this correspondence, now saying that the fact that Mr. Beck has not disavowed the 3-month time frame should be taken into account by Your Honor. Again, the defendant provides an incomplete picture here. We informed the defendant that no expert has been engaged, no testifying expert has been engaged by the claimant for the IT report. FTI has been engaged as a firm with respect to the matter, but no testifying expert has been engaged, and it is therefore should be clear that Mr. Beck cannot comment on the length of any kind of report that may or may not be instructed to him or someone else. It is therefore unclear why the defendant continues to rely on this correspondence. And therefore, we do suggest that the CMOL needs to be simply ignored. Of course, there's also the issue that Mr. Beck is a forensic IT expert, and the defendant's complaints regarding the delay and the quantum, etc., all relate to the quantum side and the quantum expert. So again, it's not clear how that is even supposed to be relevant. But that completes the second point, Your Honor. As I say, there are some minor issues that I hope the parties can sort once these two significant issues are determined. So with that, unless you have any further questions, I will hand over to Defendant's Counsel.
Thank you. Let's hear from the defendant.
Thank you. So I'll just start off first with this issue about particularization of the causation and quantum case, and it's actually a very simple point. Your Honor, can I take you to page 34 of the case management conference bundle? So page 34 is partway through the amended particulars of claim of the claimant, and at the bottom of that page is paragraph 54 of the particulars of claim, injunctive relief. Have you been able to access that
Just
page, Your Honor?
please. Yes.
So, bottom of the page, paragraph 54, claimant seeks injunctive relief, and then over the page, subparagraph A, the claimant has already lost a significant number of clients and will likely lose more. As of the 27th of August, 10 clients have definitely moved, 60 clients have left, also likely to the defendant. A further 23 have left, possibly to the defendant, and 6 clients have been affected. So in the particulars, they've identified specific clients, given specific numbers, but not identified them by name. And just scrolling to the bottom of this page, paragraph 55, subparagraph A, pleaded that the loss of profit suffered by the claimant due to the defendant using the confidential information to solicit the business of the claimant's clients. As of the 27th of August, the damages are estimated to be a very specific number, £17,843,834.70. They haven't broken down how this is calculated. Can I ask you then to turn to the defence at page 53 of the bundle. Page 53 of the bundle. At the bottom of page 53, we have paragraph 56 of the defence.
Okay.
Paragraph 56, subparagraph B. It's written, the claimant has failed to particularize the names of the clients it alleges have left as a consequence of the defendant's alleged acts. And unless and until particulars of the same are provided, the defendant expressly reserves its right to plead further. So the names are not provided. The defendant makes an issue of that. And that's exactly what the defendant's request for further information is about. It's clearly a point raised in the proceedings. The claimant knows who it's alleging has left. It knows how it's particularizing its losses, but for some reason, it's refused to date to tell us who these clients are. And until we know that, we aren't able to prepare our case. Now, I don't want to get you involved, Your Honour, in all of the correspondence between the parties over the preceding weeks. And for one reason, you don't have all that correspondence before you, and it doesn't particularly matter for today. But the parties are clearly in disagreement about case management steps to be taken, but the defendant is not delaying. The parties just have a different view of the timescales involved, and we haven't been able to agree what those timescales should be. Now, having looked at the particulars and the defence, there is clearly an issue between the parties, and clearly it's a point raised by the defendant that we don't know who the clients are. And the problem with the claimant's approach, saying, well, we don't need to name these clients, is that the defendant has no idea of the case it must meet. And in disclosure, it means the defendant would have to search all of the documentation it has in relation to all of its clients. But that's obviously totally disproportionate. The better and proper scenario is that the claimant says who it alleges the defendant has solicited. It knows which clients it's lost. It's given a precise number of clients in the particulars of claim and pleaded a precise figure for loss. And the defendant can then use those names to conduct a proportionate search of his documentation, and then standard disclosure can take place. The defendant has tried to explain to the claimant that it needs to particularize its case. It's done this in correspondence over the previous weeks, and the claimant has declined to do so. And that's why the defendant was forced to make the RFI. And having asked for those details in the RFI, the claimant has said it will respond substantively by the 12th of January, so Friday. And just looking then at the RFI, just to see what information we're anticipating receiving on Friday, it's at page 53 of the bundle.
Okay.
Page 53 of the bundle, we can see towards the bottom of the page, the heading paragraph 54 is the same paragraph I've just taken to Your Honour. We've asked for a schedule which sets out the name of each client. Oh, sorry, I've said 53, but in fact it's page 73 for the RFI.
Okay.
So page 73, we've asked for a schedule for each client which sets out their name, so the category into which they fall, so whether definitely moved to the defendant, left, also likely to the defendant, the date on which they're said to have left, the value of the assets moved away. So we're going to get a whole, presumably, all of this information on Friday.
This was agreed between the parties that you receive it on Friday?
We originally asked for it sooner, and the claimant said that they were unable to respond. I think we'd suggested the 2nd of January. They're unable to respond by then due to the festive period, and so they wrote to say that they'll respond substantively by Friday.
Mm-hmm.
So turning then to standard disclosure. The claimant says that should take place tomorrow, and we say it should take place on the 29th of February. Your Honour, in my submission, this is an easy decision for you. Tomorrow is a ridiculous suggestion, whereas 29th of February is sensible for two reasons. First, it's workable for both parties. And second, it accounts for the claimant's response to the defendant's request for information. So as to workability, quite simply, the defendant isn't ready to do standard production tomorrow. In submission just now, Ms. Burt noted the fact that the case plan would usually provide for a period of weeks after the CMC for standard production to take place, not a period of one day. And if the court were to order standard production to take place tomorrow, I'm afraid that the defendant will find itself back in the position of having to apply back to court for a variation to that order, because we simply cannot comply with that order tomorrow. And it's important that the defendant has a reasonable period from the CMC for disclosure. The second reason the fact that the claimant's response to the defendant's RFI has not been provided. This is important because the defendant needs to know the names it's alleged to have solicited in order to undertake searches of its documentation. While the claimant says the defendant's the only person who knows which clients it's taken as a result of its wrongdoing, the fact is the defendant denies any wrongdoing. We deny soliciting any clients as a result of wrongdoing. The whole claim is denied. In my submission, it must have the opportunity to search for documentation on which it will rely for standard production, and that must take place after the RFI has been responded to. Given that we'll be provided with the names of 99 clients, hopefully on Friday, that will need a period of time. It's not a fair point to say that the defendant should have been preparing for standard production weeks ago. Directions hadn't yet been made, and the defendant is not obliged to work towards an arbitrary deadline which the claimant has selected. The real reason why the defendant's in this position, why there needs to be disclosure taking place at the end of February, is because the claimant has chosen not to articulate its case on causation or quantum, which means that the defendant is unable to commence its work to prepare for disclosure. And just to explain in concrete terms, until the claimant gives us the names of these clients, we can't conduct searches of documentation. And because the defendant needs the opportunity to search his documents and see, say, if there's an email from a client, an email which says, which shows that the client has approached the defendant out of the blue, says, I've heard you've joined, I want to move to the defendant. Clearly, the defendant will want to rely on that email for the purposes of standard production. It would be an email which demonstrates no solicitation or misuse of information. But when we don't know the names, it clearly can't do those searches, at least not in a targeted or sensible way. Now, another point relied upon by the defendant is the fact that the defendant uses an outsourced IT company, and we need more time because they need guidance. There's nothing wrong with outsourcing IT. It's just a matter of practical reality that it can be harder to ensure the disclosure and searches are done properly when working with an outsourced company. We're not seeking to avoid our duties to the court as the claimant has suggested. The defendant's keen to ensure that duties to the court are discharged. It just needs more time to do so. And for that reason, we say the 29th of February is a reasonable period to comply. I'll address you then on the deadline for reply expert reports. So we ask for 3 months, and we ask for that for two reasons. First, the claimant's own expert says that 3 months is a reasonable period. And second, our expert doesn't yet have any information, but the claimants do. It makes it fair if our experts have 3 months. Now, it's worth taking you to the email within the bundle from FTI, just so you know. It's at page 122 of the bundle, Your Honour. 122.
Okay.
So it's an email just at the top of the page from David Beck on the 15th of December to Ben Brown and David True, so to my instructing solicitors. And the second paragraph of that email, equally, could you please confirm who the claimant is? We need to submit a CC and concerned we might be conflicted. On timelines, the 3 months you suggest seems reasonable, but discussion to confirm numbers of defendants and potential scale would help in being more certain of that. This is the email we submitted. not trying to mislead or obscure the details, as the claimants keep suggesting. I think it's pretty clear from that email that they didn't have the full picture. Of course, they didn't have the full picture. We hadn't instructed them. Indeed, it's the claimant's expert. As we found out in that email, they were concerned they might be conflicted. Now, if anything, the fact that they were concerned they might be conflicted in their email gives this more force. They knew they might be the claimant's expert. It's a very strong allegation to make from the claimant that it's unprofessional and inappropriate to rely on this email. And I'm afraid this is exactly the way that the claimant and the claimant's solicitors have been conducting the litigation to date, being unnecessarily adversarial and resorting to accusations and allegations against the defendant and their solicitors whenever they disagree with the defendant's position. Doesn't take the matter any further. I think it's best to focus on the substance of this email. Now, we accept the view from the expert wasn't given with full details of the claim. But they say 3 months is a reasonable time period. And in reply to the claimant's solicitors later, Mr. Beck doesn't suggest a different timescale. So, Your Honour, what you have is a pertinent bit of evidence before you. The claimant's own expert thinks 3 months is a reasonable time period. Taking a step back from this email and just looking at the principle, the claimant's experts can start work now. Indeed, they could have started work weeks ago. There's two issues on which expert evidence is required. Forensic IT in relation to whether information was taken from the claimant's systems, and quantum. So on forensic IT, the evidence base for that is the claimant's IT systems. The evidence base for quantum is the claimant's client list, their charges, and the value of the accounts that they say they've lost. Only the claimant has access to this information. The defendant has none of this documentation. The claimant can provide this information to their experts right now. The claimant suggests that its quantum expert will rely on data and information obtained through disclosure and witness statements from the defendant, but it's hard to understand how that can possibly be true. Its losses depend on the value of the assets that have left them. The defendant doesn't have that information, the claimant does. So the position is, as a matter of practical reality, that the claimant's experts have months to produce their reports. And the claimant then says the defendant's experts should have 3 weeks. And that's completely unfair, we say. Now, as to the nature of the reports themselves, so focusing on quantum, the claimants referred to 93 clients plus 6 clients who were affected and losses of £17 million. That's a lot of clients, and it will require the experts to consider losses in relation to a vast number of clients. Clearly 3 weeks is vastly insufficient. The defendant is not seeking to delay. The defendant is seeking to ensure that it's on an equal footing with the claimant and that it's afforded the opportunity to properly defend the claims. Of course, we understand that the claimant desires speed, but equally, the claimant's desire for expedition cannot trample over the defendant's right to have the case dealt with justly. The court should ensure that the parties are on an equal footing. Currently, the defendant is fighting this battle with one hand tied behind its back due to the lack of particularization. The claimant also now wants a head start, and that's completely unfair. And that's why we say a period of 3 months for reply expert reports is an appropriate time. So just to summarize, we ask for 12 weeks, 3 months for 2 reasons. One, the expert we have approached have agreed that 12 weeks is a reasonable timescale. And 2, clearly as a matter of practical reality, when looking at the position the parties are in, that's the timescale that's going to be needed. Your Honour, unless there's anything you wish to ask me, those are the points I'd wish to make on relation to the 2 issues.
Thank you. The claimant may respond.
Thank you, Your Honor. I will have just a couple of minor response points. I have addressed most of the issues that have been just addressed by Defendant's Counsel already. On the issue of standard production and the repeated comments that a list of clients is somehow necessary for the defendant to produce its initial documents, I would just like to refer, Your Honor, to the order of Sir Justice Cook, which is in the bundle at page 105. Sorry, I think it's 100. Yes, the 105 is the second page. So the first page is on page 104, the initial order of penal notice. And as I mentioned earlier, in accordance with that order, the defendant was already required under item 2 on page 105 not to directly access, pass on, make use of, derive new materials, etc., from the applicant's confidential information. There's then a similar order relating to preservation and delivery up. And if you go down a few pages to page 100, and I think it's 111, exactly, on page 111, you have a schedule which sets out what the confidential information of the applicant is. And there we had defined confidential information of the applicant, which comprises records, documents, etc., information about the business, of the claimant, of the applicant, secrets relating to the applicant, extracts created by the respondent consisting in whole and part of the confidential information. And then item 3, that's on page 111, we mentioned that for the purposes of this order, confidential information includes information acquired by, and these are the 4 individuals, the 4 employees that have moved, the former employees. So why I wanted to raise this briefly now is that the defendant has already confirmed in response to this order that it has searched its records relating to this confidential information as ordered. According to what the defendant has said in response to this injunction, it has already searched all of these records regarding to all of this confidential information. There was no comment at any point that it doesn't know what the confidential information is until we give it a list. In fact, if we now take the defendant's comment to its logical conclusion, if the defendant now says that it doesn't know what information is confidential because it doesn't have a list of our clients, then it cannot have complied with this order at all. There is a simple illogicality here, which I've already addressed, so I will not repeat it again. The defendant clearly knows the clients that have moved. It has searched those clients already, and any comments that have now been raised are simply belated attempts to delay the proceedings. That's on the standard disclosure. And on the expert reports, really, I can only repeat the fact that the defendant now again brazenly goes to this FTI correspondence when the expert said that they're conflicted, said they cannot assist the party, never permitted for this correspondence to be relied upon, and had made comments which it was not aware would be put before the court without any specific information. This type of information should not be put before the court, should not be put before the court in an incomplete form with the initial correspondence withheld, which actually set out the scope that had been proposed. I have said this already, but it is a significant point that this has now been referred to again in submission. And overall, as a final remark, we have heard now that the defendant finds it unfair that it has to submit documents and start a disclosure within short order, and that expert reports should be expected in 3 weeks. That is, of course, as I've addressed, part of the DAC court case plan. Both dates are in accordance with the case plan. In fact, standard disclosure should have happened already if the case plan had been complied with. And as such, if the defendant finds these dates unfair, it seems that the defendant simply finds the whole litigation process as per the DAC court case plan unfair. But there is nothing specifically with respect to this matter, which has been pointed out by the defendant, which makes this particular case any more unfair than any other case that would be running in accordance with this case management order. And as such, our position is very simple. We insist that the case management order, case plan of the DAC court guides the overall timetable that is agreed. And the very significant extensions on these 2 dates that are being sought are disproportionate. That's all I will say. But I'm, of course, available if there are any questions, Your Honor.
Okay, first of all, the case plan is an automated plan that is generated once you file the claim. And the most important part is the case management conference part, which depends on the circumstances at this stage and how the case will move forward from today. So it is unreasonable to have standard production of documents start tomorrow. This is my view in this regard. It's so unreasonable to have it tomorrow, especially if there is a request that is made by the defendant for more information, which, as I understand, it's supposed to that they are supposed to receive on the 12th of January. So it doesn't make sense to have the standard production of documents starts tomorrow. But again, it's not also reasonable to have it on 29th of February. Yeah, this is a very long period of time from today. That's more than 7 weeks, I believe. So in order to keep it fair and reasonable, the standard should at least start 15 to 20 days from today. So it's by the end of January, and not tomorrow and not 29th of February. And in relation to the expert response to the expert report, yes, I agree that 3 weeks is a short period of time, since the claimant will have from January to May to review for the expert to finalize the document. I'm not sure how long does the expert requires to finalize the document, but it is as per the schedule, the claimant will file and serve the expert report on the 1st of May, as per the case management order, the draft case management order. Yeah, so both parties, the parties and respective forensic information technology experts shall meet to discuss methodology and the data required to their reports by no later than 17 January. The claimant shall file it and serve its expert report on 1st of May. The defendant shall file and serve its reply expert report by the 22nd of May. When does this start, anyways?
Your Honor, just to clarify on these dates, the first date actually you read out about the date for the experts to meet and discuss methodology. That's actually one of the small areas of disagreement between the parties, which we actually don't have we haven't. That's the point I was going to raise at the end, just to iron out. In relation to the date of the 1st of May for the claimant's report, I think that might shift depending on because of the decision on standard production. So the parties after this hearing will slot in your decision on standard production and then work through the timescales in that order. So I'm not sure of the exact date when the claimant's report will be, because it's consequential on the previous dates, and the decision ultimately is whether the defendant's reply report comes 3 weeks after the claimant's report, or whether it's a period of 3 months or not. And so just to clarify, I think you said, Your Honour, that you don't think 3 weeks is an appropriate period, and you were just saying what the appropriate period would be.
Depends on it depends on when how long until the expert report is ready and the claimant to file and serve it on the defendant. I'm trying to keep you both on equal footage. Yeah.
Yes.
In terms
yes.
of, but not 3 months to respond.
Okay.
Yeah, this
so
is unreasonable.
Okay. So the claimant had said 3 weeks. We'd said 3 months. So would a period of 2 months to respond be more reasonable? That's kind of between the middle of the parties' suggestions.
Again, it depends on when it will be filed. It will be filed on the 1st, but how long does it take to be prepared?
Well,
I mean,
this is exactly
Sorry.
the point that the defendant's finding itself in. It's that, of course, we're not sure how long the defendant will take, and that's why we sought to approach FTI to say, how long do you think it would be? Because until they prepare the report, until they see the claimant's report, we won't know how long it will necessarily take. So we're looking for kind of the long stop deadline. You know, if we instruct experts and they say, okay, we can do it in 3 weeks, then yes, it may be that the report could be provided early. I don't know, but we're looking at that kind of long stop date in case it's actually complicated and they need a lot of time. And so we need that long stop date in the directions. And that's why we were asking for 3 months being that long stop date in the directions.
If I may comment, because I think the question was directed at
Yes.
claimant's date, because Your Honour, I think you were asking how long the claimant's report, when that will be filed. So my defendant's counsel, I agree with defendant's counsel that the dates will need to shift, of course, depending on the standard production date. But in terms of the periods, as Your Honour will see, the witness statements at item 10 are due on the 10th of April. Those are the reply witness statements. That's on the current dates, as I say, that they will move. But on current dates, 10th of April are the witness statements. And then the suggestion was on the 1st of May to file the claimant's expert report. So the claimant has 3 weeks to prepare its 2 expert reports following the conclusion of witness evidence. I think the disagreement appears to be that defendant considers claimants can start working prior to this date. On the other hand, we consider that in fact it is only the defendant that can actually start working prior to this date. So that's the disagreement. But our reports will be prepared within 3 weeks. That's what we've put forward. I understand that Your Honour is minded to give the defendant more than 3 weeks. But of course, we disagree with the 3 months or even the 2 months that is now being prepared, suggested.
No, I didn't know that you for you to prepare requires 3 weeks. So if for you to prepare requires 3 weeks, then I think 3 weeks is sufficient enough for the defendant to respond. But anyways, I suggest that we keep it as 3 weeks, and then later on, if something else came up, an application to extend is sufficient at this stage. Yeah.
Thank you, Your Honour.
Yes. Yes, I mean, I think our point was essentially that they can start before witness statements are served, and I'm sure they will be starting before witness statements are served. So in reality, the claimants don't have 3 weeks.
This is an assumption, I believe. It's not confirmed that they will start before the witness statement.
Yes, Your Honor.
So I suggest that we keep it as it is, but since we have decided that the standard production will start by the end of January, the 25th or the 29th, between the 25th and the 30th of January, you can decide the date between you two. So all the dates later on will shift to accommodate the start date, yeah?
Yes. Would it be possible to pin down that date for standard production? So I think we'd say the 30th of January to put into the order. I think it'd be helpful just to agree that now.
What's the claimant's suggestion on the 30th?
I think I would suggest to the defendant that we do speak. We have, Your Honors, you have the court's indication that the 25th to the 30th is appropriate. We are, of course, mindful to make sure that the timetable works overall. So I think it's worth looking at the exact dates before we pin down the exact date, which one it is between the 25th to the 30th. Also counting backwards to some extent from the hearing, because necessarily the hearing will now be pushed. There's also the summer period in August that we will need to consider and the court's availability. So there may be some sense now with these directions from the court to speak possibly on a call to finalize these dates and make sure that they work. But we will, of course, be happy to agree any date between the 25th to the 30th as directed.
So if we can decide a date, it would be better today, yeah? So the defendant suggests the 30th of January. What do you suggest?
We are happy to compromise on the 30th if the defendant insists on this. As I say, I do think the party should be able to discuss these minor issues separately. But if the defendant insists, we'll agree the 30th now.
If you want to decide between,
delay.
if you want to decide between both of you later on, I don't mind. But it will
that would
be
be my
between
suggestion.
but it will be
Right.
between the 25th to the 30th, yeah? Not
That would be
later
my
than
suggestion.
that, or not before than that.
Yes, thank you. As I say, we are happy to cooperate with the defendant with respect to this and agree the 30th if that's what's requested. But I would suggest that we are somewhat flexible and make sure that we work backwards from the dates once we've identified the delay that's causing.
I think, okay, let's go with the position then that essentially the 30th is agreed, but if something comes up, which means that's unworkable, then of course we'll look at it.
Okay.
Thank you.
But you'll decide, yeah? You will communicate between each other and decide when is the exact date.
Yes,
I'm
thank
just
you.
making sure that the defendant understands my point.
I mean, I'm just reluctant to say this because it's been so difficult to agree dates between the parties, and I
shortened. You have only 5 days to decide on, either the 26th, 7th, 8th, 29th, or the 30th.
Well, it just concerns me that the claimant's saying, well, we're happy to agree the 30th, but then also saying we're not. So if they're happy to agree it, let's agree the 30th. And I think then at least the parties know where they are and we can just work through the directions.
The days are limited. I don't think you should complicate the matters, both of you. There are between 5 days. So it's either one of those dates. If you want me, I can choose now. But I'll give you the opportunity to communicate between each other. Maybe you build later on a good relation, so then later on you can agree more than disagreeing.
That would be nice.
So it's up to you.
Well, I think given we want the 30th, the claimants are happy to agree the 30th. I think I'd like you to decide, Judge.
The only reason I'm hesitating is because naturally, when you look at the dates and you see that certain dates may now fall on a holiday, may now fall on a on some sort of public national day, etc., you need to be somewhat flexible as you adjust all of the dates to account for this. And I am very hopeful that despite the very significant disagreement over the last 2 months, the parties are able to sort out these minor issues in light of potential later impacts on the timetable. I'm simply trying to be practical rather than difficult. So that's all. If the claimant insists, defendant insists on the 30th, as I say, we can order it, but if then there's a later impact because there's some date that now falls on a holiday which needs to be moved forward or backward, that's the type of issue that I'm trying to avoid right now.
Well, of course, we'll agree. If other dates need to be adjusted because of a holiday, of course, that'll be accommodated in the timetable. No problem, of course.
That's why I'm suggesting to keep this currently flexible, to see the impact on the timetable, and then we will agree one of those dates. I really hope it's not controversial in any way. And as I say, in any case, I've already confirmed we'll agree the 30th if there is no such impact, if there's no other impact on the remaining days.
Okay. Anything else?
Yes, there's the final issue to be decided in relation to the date for the pre-meeting of experts. So in the claimant was asking for that date to take place on the 17th of January, and we were suggesting that should take place on the 7th of March. And this is the date to discuss the forensic IT experts to meet to discuss methodology and data required. So claimant saying 17th of January, we're saying the 7th of March, essentially 7th of March being that it should take place after standard production has taken place, a week after standard production. We haven't yet been able to instruct our experts, so for this meeting to take place next week is clearly far too soon.
I agree with the defendant on that.
And my apologies. In fact, we have not instructed experts either, so my apologies that this January date is in any case, I do agree, it must be a typo, but our apologies on this. This is a recent addition to the timetable. We have not yet instructed testifying experts, as I've said earlier, so of course this date would not be possible. Sorry, the defendant was suggesting for the date to be the 7th of March, which is immediately after.
I think it'll need to be adjusted now. So we would say just a week after standard production is what our proposal was. So
a week after standard production.
Mm-hmm.
Okay. I mean, I wonder whether maybe that's where the issue crept in. I wonder whether we should discuss this date as well, because even a week after standard production may be still somewhat early, because obviously both parties will need to instruct experts first. But I wonder whether that's an issue that we can take up as well on a separate call. And maybe what we could do as well, rather than have a specific date, include a window, because this date will of course also depend on the expert's availability. So if the defendant is agreeable to that, that may be an alternative.
Okay, if the parties fail to agree, I will decide the dates. Yeah, okay. But it shouldn't be a problem to be for this date to be decided, I think.
And the final issue now, given your decision, Your Honour, on the timetable for reply expert reports, is given that our reply expert reports at the moment, the period is 3 weeks, and our issue, we said, is they won't have access to information to prepare that. I wonder if to remedy that issue, it would be helpful to have an order such that if the defendant's experts need access to information from the claimant to prepare their reports, and they want to prepare that prior to disclosure and witness statements, that they can request that information, that information can be requested from the claimant, and the claimant can provide that information to the defendant's experts
This
by
should be
a prior date.
This should be by an application at that point
Okay.
of time. But I think a request for production of documents should solve those issues, because you'll request the documents you require in order to prepare your claim, yeah?
Yes, it was about a slightly different issue in relation to the expert reports, but I think you've given your decision on that.
Yeah. Anything else?
Not from the defendants.
When should the court expect the draft case management order?
Well, I expect claimants probably have carriage of the order. When do you think, Ms. Burt, that you'd be able to address the order by and then send over to us?
We'll be able to do this later today, so we'll send over the amended order in light of Your Honour's directions later on. So subject to the defense ability to consider the dates, and as I say, if there is a need for a brief phone call to iron this out, then that may help to finalize the dates faster.
Okay, thank you. Anything else from the parties?
No, thank you.
Thank you, Your Honour. Nothing else from us.
Thank you. Thank you, both parties.
Thank you very much.